with you this morning on a Thursday. Bishop on Air, live with you across the internet. Just search Bishop on Air and we can connect that way. Appreciate all the messages people send throughout the day and even phone calls I get from time to time. With your thoughts and feelings about some of the topics that we cover here on the program. So I appreciate you being here. We'll have to talk about a Cook County judge declaring that Donald Trump should be removed from Illinois' primary ballot. So that's coming up. Also, we've got to hear some of what was discussed yesterday in the U.S. Supreme Court. So that as well is coming up here with Bishop on Air. Like, subscribe, hit that notification bell. Join me each and every weekday morning here. Good morning to those jumping into the live feed. Jordan, Marty, David, Tenebris, Just Someone. Appreciate that from Rockford. Joss, Sergio, Pat, Tom, Captain Mike, Brett, and so on. AJ, Christian, Christopher. Appreciate you all being here and streaming with me each and every weekday morning. All right, so stay tuned. Plenty to get to. We'll start with some of the highlights from yesterday's U.S. Supreme Court hearing on the bump stock ban and what that could mean moving forward when it comes to the ATF being able to create rules that ultimately have criminal penalties. So stay tuned. That's on the way here with Bishop on Air. Can the ATF create laws by rulemaking when it comes to regulating things that Congress should be making laws on? That was a big question at the U.S. Supreme Court yesterday in the case challenging the ATF's rule banning bump stocks. Of course, the background on all of this we talked about yesterday. If you missed that segment, go back and check that out with Bishop on Air. I'm Greg Bishop. Thanks for hanging out. Like, subscribe, hit that notification bell, and if you want to find out more about me, go to bishoponair.com. As I hang out with you each and every weekday morning from my home studio, this is all on my own time. Just enjoy flexing that talk radio muscle. After doing it on terrestrial radio for 15 years, I decided to work smarter, not harder, and just do something from home. And just blessed with the growing audience. So again, be sure to like, subscribe, and hit that notification bell. All right, let's get right on into it with the U.S. Supreme Court and their hearing yesterday in the challenge of bump stocks. Let's go ahead and get into this. And there was a lot of back and forth between the justices and the government attorneys in the ATF and the Department of Justice, talking about understanding a rule and what kind of impact that rule has. So here's some of the questions and comments back and forth between the various litigants, including the Supreme Court justices.
One of the reasons, to Justice Gorsuch's point, this is an interpretive rule that went through notice and comment. The reason was in part because the agency knew that it had previously been saying something different. It wanted to maximize public notice. This is something that's gotten a lot of attention.
Why not require the government to also prove that the person knew that what they were doing was wrongful, was illegal?
Yeah, well, I think that's not the understanding that this court adopted in Staples. If the court wanted to revisit that in another case, a criminal case, you could. We haven't briefed that question here. But I think to the extent that you're concerned about that, it's not a concern unique to bump stocks. We mentioned all sorts of other devices, the forced reset trigger that we mentioned. The problem of people coming up with devices that they think get close to the line but don't go over, but that in fact go over the line and turn them into machine guns isn't new and could come up anywhere. The problem here, we acknowledge, is ATF used to say something different about these, but we think that's taken care of by the rulemaking and the doctrine of entrapment by itself.
Because people will sit down and read the Federal Register.
No, I think because people who have these devices...
That's what they do in their evening for fun.
One of the reasons...
Right. The federal, those who are gun owners wanting to comply with the law, but finding it difficult to do so, especially in the landscape of ever-changing regulations, like just administrative body changing rules. So clearly some interesting questions there from the justice to the government's attorney. Some other things that were brought up, understanding the function of a trigger and what that means, and looking at some misconceptions that there may be. Here's more of the back and forth between justices and the litigants.
I'm sorry, Justice Jackson.
That's wrong?
Rapid fire is not the test under the statute. It's not whether it fires rapidly. It's whether it fires more than one shot automatically by a single function of the trigger.
I'm sorry.
Okay.
They said it could, but what we focused on was not whether that metal piece changed the way the trigger operated. Now, maybe you're saying that's wrong, but I guess what I'm focused on is that your argument seems to rest on the assumption that the function of the trigger, as Justice Alito says, is what the trigger does inside the gun.
That's correct.
Why is it irrational, wrong, etc., to think of the function of the trigger as what it does to cause the weapon to automatically fire more than one shot? If that's what we mean by function of the trigger, which is in the statute, automatically more than one shot, and what we're saying is if one operation causes the trigger to causes the function of the trigger to make the weapon automatically fire more than one shot, I guess I don't understand why your reading is preferable to that when the common understanding of a machine gun is that it is doing this sort of thing at the end of the day.
Well, it's because the trigger on a bump stock equipped rifle does not cause the rifle to automatically fire more than one shot. You still have to have manual action by the shooter in response to every single shot that gets fired. The shooter has to continue to thrust that forestock forward.
Okay,
with his
and if
non-shooting
that's
hand.
true, that's true.
It is true,
that is
yes.
Okay, that is a distinction. My other question then comes in. Why is that distinction matter from Congress's perspective in terms of it writing a statute that it was trying to prohibit that?
So again, the questioning back and forth about Congress's role in this, the ATF's rulemaking authority. Can they craft laws by rule that have criminal consequences? These types of things being brought up yesterday in the U.S. Supreme Court. Also, a conversation about the legislative history and the function of these triggers. Something that should Congress have addressed these questions.
And they're all wrong because the statute also was written to encompass weapons that have push triggers rather than pull triggers. And the Solicitor General acknowledges this point in her opening brief.
So what it suggests to me is that, contrary to what you're saying, that is they never understood this to be how the trigger functions, but how the shooter functions.
No, I think we should draw the exact opposite inference. It proves how unreliable legislative history is as a tool to try to discern what the statute means. It's because, Justice Sotomayor, the phrase pull of the trigger can't be equated with function of the trigger. And even the Solicitor General acknowledges that because they say in their brief that the statute needs to be read in a way that encompasses fully automatic weapons that have push triggers rather than triggers that are pulled.
And you
so
agree.
the word function, I'm sorry, go ahead.
And you agree.
I agree that function
But
can't
the
be
only way
equated with
you
the
can
word
get
pull.
there is by looking at what the shooter is doing.
No, that's
Okay,
not correct.
counsel,
You don't
thank
need to look at what the shooter's doing. A weapon can go off by accident. You don't need a shooter. There's still a function of the trigger. If the weapon falls onto the floor and goes off accidentally with a discharge, the trigger has functioned, even though the shooter hasn't pulled the trigger or pushed it or bumped it. What matters under this statute is what the trigger does. And all these examples that we see in the Solicitor General's brief, Justice Gorsuch mentioned this earlier, when they're taking transitive verbs, when they say swing of the bat, or stroke of the key, or roll of the dice. All of those are transitive verbs that are capable of taking an object. So when you see swing of the bat, there's obviously an unnamed actor in that sentence that is the subject of the verb swing. And
the attorneys making their case in front of the U.S. Supreme Court with a variety of different arguments, getting into the technical specifications of the bump stock and how it manages recoil and the action of the individual holding the firearm and even the intent of the individual holding the firearm, even more from yesterday's hearing in front of the U.S. Supreme Court in the case Cargill versus U.S.
Mr. Fletcher agreed with us on that point. The hand is moving. I think where our disagreement comes in is that Mr. Fletcher seems to characterize the action of the non-shooting hand, so the left hand for a right-handed shooter, as something where you are applying constant pressure in a certain direction, but the recoil is strong enough to overcome that pressure from the non-shooting hand and thereby move the weapon backward despite the forward pressure that's coming from the non-shooting hand.
But that means tell me if I'm wrong, but that means that the way a shooter perceives it is by imposing constant forward pressure. Not the shooter is thinking, I got to do this really fast, going back and forth.
The shooter can do both, and it takes a lot of practice to master the art of bump firing. So there is always going to be recoil energy, and no person, I think, is strong enough to push forward in a way that overcomes the recoil energy. If they were, bump firing wouldn't happen. So for successful bump firing to occur, there needs to be that back and forth motion. There's recoil every time the rifle fires. There's still pressure from the left hand, or the right hand if you're a left-handed shooter. There's still going to be pressure from that non-shooting hand. But the shooter can decide how much he wants to calibrate that pressure in response to the repeated recoils that he's getting from the bump firing. It doesn't have to be the same amount of pressure each time. The shooter just has to make sure that the hand is moving back and forth, because that's the only way you can have successful bump firing. But to get back...
So, again, getting into some of the specifications here of how it works and trying to get these Supreme Court justices, who I don't know if they've ever fired a firearm with a bump stock on it. It seemed that was a lot of the focus, is the functionality of the trigger, the intent of the individual, whether or not they have the intent of using that for the specific purposes. It goes on and on and on about even the question around machine guns and how this could equate to what a machine gun is.
I welcome the court's questions.
Mr. Fletcher, how does a machine gun, what would I have to do to fire a machine gun?
It depends on the machine gun. Some it's a push of a button. Some it's a pull of a trigger. The statutory definition is, does it shoot more than one shot automatically by a single function of the trigger?
But I don't have to do anything else. I don't have to put pressure on it or anything else.
It depends on the gun, again. So if you imagine, I think what your question is getting at is, if you take a traditional M16 rifle, that we often think of when we think of a machine gun, you're right. To fire more than one shot, you pull the trigger and you have to hold it back, and as long as you maintain that backward pressure on the trigger, it keeps shooting.
With a bump stock, what would I do different?
You would do different, both the initial motion and the motion that continues. It's the same thing in the sense that one motion automates back and forth movement and results in multiple shots.
So what is happening with a trigger initiated firing of a machine gun? What do I have to do other than to press the trigger?
With a traditional machine gun, again, take an M16, and again, we think they're all machine guns, but I understand the question to be, take an M16, you pull the trigger back and you hold it and it keeps shooting. Okay. With a bump stock, you push forward and that both initiates and continues the firing.
And what?
So, the technical questions, obviously something that court's going to consider when they take this under advisement, which they did yesterday. No ruling from the bench. Rarely ever see that, if ever, from the U.S. Supreme Court. But also the question of mens rea, and I believe that means state of mind, and whether that plays into this at all.
I ask you about mens rea, to pick up on Justice Gorsuch's questions, for prosecuting someone now. What mens rea showing would the government have to make to convict someone?
So I think the relevant case is Staples, and I think what the court held in Staples is that you have to be aware of the facts that render your weapon.
So even if you are not aware of the legal prohibition, you can be convicted?
That's right. But that's true of all machine guns. I mean, all different sorts of devices. I think the distinct problem here is the one that's created by the fact that the agency was previously saying that these were not machine guns. We acknowledge that those people who, in reliance on that...
That's going to ensnare a lot of people who are not aware of the legal prohibition. I ask you about...
So, again, you have even the government acknowledging that they hadn't previously considered these machine guns, but the change of the rule in the Federal Registry that everybody reads at late night, right? I mean, you pull that up on your phone, you go through the PDF, and you read thousands upon thousands of pages to see how new federal regulations are impacting you directly, right? Especially when they have criminal penalties associated with it. But you've got also the just overall theme of gun control and the language that's used and the implications of laws on people. Here's even more from yesterday's hearing in front of the U.S. Supreme Court.
Justice Kavanaugh?
You've referred a lot to the language in 1934 and around that time, but of course bump stocks didn't exist around that time. What are we to make of that?
So I think you still apply the language, and you have to do what you have to do a lot, which is apply language that Congress wrote and apply it to something that didn't exist at the time. You know, none of these workarounds, the fishing reel, the auto glove, the force reset trigger, all of them are new problems. But I think what you can draw is that Congress wrote a statute, chose the word function deliberately because it didn't want to just focus on triggers that pull, And then in 1968, it added parts that convert a normal gun into a machine gun because it recognized that people try to do things to semi-automatic weapons in order to give them these same characteristics of multiple rounds with a single manual action.
And then what's your explanation, maybe common sense explanation or some other explanation for why, when this does become an issue, the Bush administration, the Obama administration, Senator Feinstein all say no?
Yeah.
Bump stocks are not covered, because if it were so, I don't want to use the word clear, but if so, if your position were correct, this is a new thing, obviously covered by this old statutory language, you would expect the Bush administration, the Obama administration, Senator Feinstein to say, of course it's covered by, and they didn't, and that's reason for pause. It's not dispositive.
So again, the lack of actual congressional action, and even the lack of action from previous administrations before the Trump administration, being highlighted by the justices in their questioning of the various litigants in this case. You've also got just the issue of the Second Amendment coming up in all of this, and how exactly this comports with that, how the controversy rubs up against constitutional rights like the right to keep and bear arms.
We think the function of the trigger is what lets the shooter start the firing sequence, and we think all of the parts of this statutory definition are aimed at, we're worried about guns that let you shoot many shots without repeated manual actions, right? So it's a single function of the trigger. Does the shooter have to do one thing or many things?
Thank you.
On that score, can we just step back a minute? I can certainly understand why these items should be made illegal. But we're dealing with a statute that was enacted in the 1930s. And through many administrations, the government took the position that these bump stocks are not machine guns. And then you adopted an interpretive rule, not even a legislative rule, saying otherwise, that would render between 250,000 and 500,000 people federal felons, and not even through an APA process they could challenge, subject to 10 years in federal prison. And the only way they can challenge it is if they're prosecuted. And they may well wind up dispossessed of guns, all guns in the future, as well as a lot of other civil rights, including the right to vote. And I guess I just want your reaction to that.
Well, it's a great question, and something I think we'll definitely hear a lot more about as we anticipate a ruling from the U.S. Supreme Court on this issue in the months ahead. So there's a bit of a review of some of the things debated yesterday in front of the U.S. Supreme Court. Appreciate you guys being here, as always, with Bishop on Air. Like, subscribe, hit that notification bell, and stay tuned. Always more to come here with Bishop on Air. Former President Donald Trump should be removed from the Illinois March 19th primary ballot, so says a Cook County judge. And Trump's campaign firing back, saying that they are going to immediately appeal. Welcome back. Bishop on Air with you. And let's take a look at this. Of course, like, subscribe, hit that notification bell. We covered a bit of what the Illinois State Board of Elections decided. They were unanimous in saying that Trump should stay on the ballot because the State Board of Elections doesn't deal with the constitutional law that was being brought up. And, some people even saying that Trump's not been charged with insurrection or even found guilty of insurrection. But after the Illinois State Board of Elections unanimously said that Trump should remain on the ballot, those challenging Trump's access to the ballots appealed, and they went to the Cook County Circuit Court. So this is state court. All right, so we have this ruling that was issued yesterday from the Cook County judge in this case, and the judge spelling out all of the background of the case and the justification for removing Trump, looking at the Constitution, looking at the 14th Amendment, even spelling out that the Colorado Supreme Court has decided to remove Trump from the ballot there. And while that's being discussed by the U.S. Supreme Court after they had heard the challenge in the nation's high court several weeks ago, they haven't ruled on it. So the Cook County Circuit Judge says that the Colorado Supreme Court is still law that they should interpret. Posted a story this morning about it, so go check it out at thecentersquare.com, where you can see Judge rules Trump's off Illinois' primary ballot. But important to note, a stay has been issued on that ruling until March 1st, which, that's tomorrow, because of an expected appeal. So while the judge saying that Trump should be removed off the ballot, you have that 38-page ruling saying until the U.S. Supreme Court renders a decision in Anderson v. Griswold case, now pending before the U.S. Supreme Court, reviewing courts are still under a constitutional obligation to interpret the law and especially continue the momentum of the election process in light of the March general primary election. Trump's objectors, she said, have met their burden by a preponderance of the evidence. Her ruling also said that the state elections board was clearly erroneous in denying the objection, and the board was in error, finding that the respondents' candidates' nomination papers, including a statement of candidacy, was valid, and the board's decision to keep Trump on the ballot is reversed. So again, the judge ordered the State Board of Elections to remove Trump from the March 19th primary ballot, but put on hold her order until March 1st in anticipation of an appeal. So Trump's campaign, they promised an appeal, saying that political groups are attempting to interfere with the election and deny Trump his, quote, rightful place on the ballot. Here's that quote where you've got, let's go back here. Today, an activist judge in Illinois summarily overruled the state election board's contradicted earlier decisions from dozens of other state and federal jurisdictions. That's Trump spokesman Stephen Chang, saying that this is an unconstitutional ruling that we will quickly appeal. In the meantime, President Trump remains on the ballot in Illinois, is dominating the polls, and will make America great again, the Trump campaign says. Trump's already dominated Republican primaries and caucuses in several other states, becoming the Republican Party's presumptive nominee. So I guess we'll just have to watch this play out even further. And it goes to the appeals court. Who knows? Maybe it'll be rushed to the Illinois Supreme Court, where they may have to bring this up and decide what's going on. But in the meantime, you could have the U.S. Supreme Court just say, all right, enough. Here's our ruling. Trump is off the ballot or Trump is on the ballot for the March 19th primary. We've got a lot to talk about the March 19th primary because, of course, you've got congressional seats that are up for grabs, but you have a ton of other things as well to consider, including state health, right? So, yeah, back at it tomorrow. One day of good streaming, the next day, a couple of drops. What are you going to do? If you missed anything from the live stream, be sure to check out the feed that we put out throughout the day. Right after the program, we upload the segments, so you can check that out, all right? Appreciate you guys being here, and we'll be back at it tomorrow here with Bishop on Air. All right, just a few things, guys. Somebody's asking about an update on the case with DeVore. Thomas DeVore had a case where he is asking for an individual to be declared a peace officer, thereby exempt from the gun ban. Sent him a text this morning, see if we could connect later after what I thought was a hearing today, but he said the hearing's been delayed and they've requested a new judge. So, interesting. So that's an update on the DeVore case. No real updates I have for you from the McGlynn case in the Southern District of Illinois, with Judge McGlynn having the conference yesterday with attorneys to give that path of what's going on and the challenge against the state's gun and magazine ban. So we'll get you the latest on that. Maybe we do a recap tomorrow. But also tomorrow, we've got Friday, so we'll open up the Discord channel as well. Appreciate you guys being here each and every weekday morning, and I know the live stream thing's been frustrating, but again, that's why you need to like, subscribe, and hit that notification bell, and head over to the YouTube channel and check out the segments, because those are recorded locally, so we can get those up uninterrupted. All right, guys, have a great day. We'll see you back here tomorrow with Bishop on Air.